Back in the 19th century on the American frontier, law and order had a hard time keeping up with the wagon trains. It was called the Wild West, and not without reason. For among all the mostly law-abiding settlers in these new territories were plenty of outlaws. Today, their names are legend. Because of the vast distances, the harsh terrain, the difficulties of transportation, judges and juries were often difficult to find. Nowhere was this more true than in West Texas, where lived a man named Roy Bean. Born in Kentucky of a dirt-poor family, Bean traveled to California as a young man. There in the 1850s, he ran a saloon and trading post and served in the militia. But he had a fondness for alcohol and was often in trouble with the law. During the Civil War, Bean operated out of Mexico, smuggling guns into Texas for the Confederate Army. After the war, he showed up in Vinegaroon, Texas, where a railroad was coming through. Bean's tent saloon sold alcohol to thirsty railroad gangs. In this desolate stretch of mountains and desert, the nearest courtroom was a week's ride by horseback. So somehow, Bean got himself appointed Justice of the Peace. He himself preferred the title judge. His credentials? Only 3 months of formal education. Eventually, Bean set up his court in a shack furnished with a bar, poker tables, and jury room. He himself was bartender and judge. Bean's jury? Whatever 12 roustabouts he could find hanging around the saloon. If they didn't vote the way the judge wanted, they could be fined or, worse yet, cut off from the judge's whiskey. In Judge Roy Bean's territory, there was no police force to arrest wrongdoers, no prosecutor to investigate and present the case, no grand jury to review evidence, no defense attorney to defend the accused. There was only Judge Roy Bean. Today, we can look back on the court of Judge Roy Bean with a touch of disbelief. Did that really happen? Well, yes, it did. But beyond its outrageousness, this story tells us something significant. The administration of justice is far too important and delicate to rest in the hands of one human being. If history has taught us anything, it's that a system of checks and balances is critical to the fair and impartial administration of justice. Here in the state of New York, these checks and balances are firmly in place. It's the responsibility of the government, as represented by the prosecution, to present evidence against any person accused of a criminal act. It's the duty of a grand jury, you people sitting here today, to review that evidence and determine whether that accusation is justified. As grand jurors, your decisions must be based on the evidence and the law, and not, as in Judge Roy Bean's court, on bias, hostility, prejudice, or whim. And as you serve, always remember that our grand jury system is designed to help protect the rights of citizens and uphold the laws of the land. I'm Ed Bradley of 60 Minutes.
My first thoughts when I received the summons for grand jury duty was, oh no.
I thought, my goodness, not again.
My first thought was how to get out of, a way to get out of it.
I knew nothing about the grand jury, nothing at all.
I wasn't sure that I could devote that much time from work.
Well, first of all, I thought it was for the petit jury. Then my husband, after looking at it, said, no, this is grand jury. And I said, what's that?
Here you are ready to begin your grand jury service, but many of you may be asking, what is a grand jury anyway, and how does it differ from a trial jury? Those are good questions. Here's a simple, brief answer. A grand jury decides whether or not a person should be formally accused of a crime. If that decision is yes, the grand jury issues what is known as an indictment. An indictment is a grand jury's formal written accusation of a crime. A grand jury does not decide whether the accused is guilty or not guilty. That's the job of a trial jury. There are other important differences between a grand jury and a trial jury. For example, the burden of proof. A grand jury determines whether there is legally sufficient evidence and reasonable cause to believe that a person committed an offense, whereas a trial jury determines whether the prosecution has proved the accused guilty beyond a reasonable doubt. As a result of these critical differences, a grand jury proceeding is generally much simpler than a jury trial. For example, a trial jury usually hears opening statements, witnesses, cross-examinations, summations. Both the prosecutor and defense attorney play active roles. A grand jury, however, typically hears only from the prosecutor and witnesses. Now, where did this idea of a grand jury come from anyway? In fact, it's been developing over 3,000 years. Around 1300 BC, Moses, who brought the world the Ten Commandments, was rebuked by members of his tribe for acting as the sole judge of his people. To help correct this imbalance, the Israelites created the Sanhedrin, body of men called upon to settle legal disputes. Interestingly enough, the Sanhedrin consisted of 23 people, the same number as today's grand juries. In ancient Greece, Aristotle wrote that accused persons should be allowed to argue their cases before a tribunal of peers to reach justice. After the fall of Rome, however, justice depended on who was wielding the sword, without judges or juries. Those were the days of trial by ordeal, in which a person's guilt or innocence was decided by how the accused reacted to torture and pain. In medieval France, King Charlemagne occasionally brought together a group of well-born citizens to inform him of any local landowner disputes or improprieties. They were called the jurare. During the 12th century in England, this general idea was given an evolutionary twist by Henry II, who required local juries to not only report on crimes, but also make formal presentments or accusations. This was the origin of the Bill of Indictment. Even so, the person indicted by these grand juries still had to undergo a trial by ordeal to establish guilt or innocence. Sometime after 1215, during the reign of King Henry III, the trial by ordeal was replaced with the more rational idea of an additional jury, one of peers and neighbors, thus instituting the petit or trial jury. So the idea of a grand jury actually predates the idea of a trial jury. But both grand juries and trial juries still pretty much voted the way the monarchy wanted them to for fear of reprisal. In the 17th century, William Penn, who later founded Pennsylvania, was preaching on a London street when he was arrested and tried for disturbing the peace. When the trial jury refused to find him guilty, they were thrown into prison. Judges reversed this case, and from that day on, no authority could punish a jury for its decision. This English system of justice came to America with the first settlers. But much to the annoyance of the English monarchs, the Americans began to develop their own ideas about justice. In 1735, a man named Zenger was brought before a grand jury in the colony of New York for publishing newspaper articles denouncing the corruption of the local English governor. The governor packed the jury with cronies and demanded they indict Zenger. They refused and struck one of the early blows for grand jury independence in pre-revolutionary America. Over the next few decades, the spirit of democracy expanded throughout the colonies, culminating in the late 1700s with the Declaration of Independence, the Constitution, the Bill of Rights. Following the lead of the federal government, the Constitution of the State of New York declares that no person shall be held to answer for a capital or otherwise infamous crime unless on indictment of a grand jury. Sometimes grand juries are impaneled to inquire into matters of the public interest. One such in Chicago investigated the 1919 Baseball World Series and found that gamblers had bribed various members of one team to lose, a team known forever after as the Chicago Black Sox. In 1935, a New York grand jury was impaneled to look into gambling and racketeering in New York City, criminal activities which were costing New York taxpayers millions of dollars a year. The findings of this grand jury led to the appointment of racket buster Thomas E. Dewey as special investigator. Using grand juries, Dewey was able to indict and jail such notorious crime figures as Lucky Luciano, Dutch Schultz, and Louis Lepke. So over these 3 millennia, the idea of a grand jury has evolved into an integral part of our system of justice here in these United States. Today, you and everyone around you are a vital part of this venerable tradition.
Hi, I'm Sam Waterston, and I'm here to give all of you grand jurors an idea of what you'll be doing over these next days and weeks. And by the way, I think you'll find it a fascinating experience. First of all, each of you will receive a copy of Article 190 of the Criminal Procedure Law, which governs grand jury proceedings. This is the legal framework. But let's take a brief look at how the whole system operates. In most instances, the process starts when a person is arrested, though there may be occasions when a grand jury is asked to consider an indictment before an arrest. Either way, the prosecutor's office prepares a presentation concerning the particulars of the alleged offense. Once prepared, the presentation is brought before a grand jury by the prosecutor. That's where your work begins. Hi, folks, come on in. When you begin your service, you'll be brought into a grand jury room much like this. As you will see, there are 23 of you, a number established in English common law centuries ago. The court will choose your foreperson and assistant foreperson. You will choose your recording secretary. A stenographer will be present to record the testimony and instructions, the official record. Once you are seated and sworn in, the prosecutor will arrive to begin presenting the first case to you, a presentation that will set forth the evidence against an alleged offender.
My name is Linda Fairstein. I'm an assistant district attorney in New York County. I'm here today to present to you the case of the people against John Doe. There is one charge being presented to you today, and that is rape in the first degree. I'm going to present the evidence, the witnesses.
The presentations you will hear may include homicide, robbery, grand larceny, narcotics crime, possession of stolen property, rape, sodomy, assault, arson, kidnapping, burglary, possession of a weapon, practically the whole spectrum of the criminal law. This doesn't mean you'll necessarily hear these cases in your grand jury term. It simply means you could. The prosecutor will present the case, call witnesses, and instruct you on the law. You will note that no judge is present during grand jury proceedings. The entire presentation is handled by the prosecutor.
And that is in section 130.35 of the penal law.
Most presentations take only a short time, although some cases might run for several days or more.
Yes, sir.
Was it light enough inside the building for the victim to get a good look at the man who attacked her?
You've heard the evidence we presented.
If you have questions for a witness, or questions about the law, or about the evidence, you may ask these questions of the prosecutor during the presentation, or you may ask to speak to a judge. The prosecutors and judges are your only legal advisors, and as you will read in Article 190, you are forbidden by law to seek or receive legal advice from any other source. You should know, too, that the accused person has a right to appear before the grand jury on his or her own behalf. He or she may also ask the grand jury for permission to present other witnesses for the defense. But keep in mind that no accused person has a duty to appear, and no unfavorable inference may be drawn if the accused does not testify. A defense attorney may be in the grand jury room to advise the accused, but is not permitted to take part in the proceedings. The defense attorney's turn will come later if the accused is indicted and the case goes to trial. And perhaps this is a good time to remind you that all grand jury proceedings are strictly secret. It is against the law to reveal anything about the cases presented to you. There are good reasons for this. This strict secrecy ensures that witnesses can cooperate fully. It encourages free and open deliberation among grand jurors, and it protects the innocent person who may be investigated but never indicted. But now back to the proceedings.
Forcible compulsion is also defined.
Eventually, the prosecutor will explain the law to you.
And it reads that forcible compulsion occurs by physical force or any threat, express or implied, that places the victim in fear of death or serious physical injury. That concludes the presentation of the evidence in this case. We're going to step outside now and ask you to vote.
And then you will be left alone to deliberate and vote. The law requires at least 16 of you to be present to make a quorum. Of these 16, a vote of 12 or more who have heard the evidence is required for an indictment. If in your deliberations you vote yes for an indictment, this means that the defendant has now been formally accused by the people of the state of New York. This case will go to a trial court, where the defendant may exercise his or her right to a jury trial to decide guilt or non-guilt. If you do not vote for an indictment, then the charges against the accused are dismissed, the end of that particular case. You should also know that as a grand jury, in addition to your option to vote on an indictment, you also have the authority in some cases to direct the filing of criminal charges to a local criminal court, or send a case to family court, or submit a report on issues concerning the public interest. The prosecutor will inform you when it is appropriate to consider one of these actions. And that's it. Now then, how important are your decisions? Well, look at it this way. Accusing a person of a crime is serious business. It is you collectively who decide whether or not to make this formal accusation. As grand jurors, you are a cross-section of the community. As such, you are serving as an arm of the court, not as an agent of the police or the prosecutor. It's essential for you to be attentive and fair-minded in hearing cases and in your deliberations. For you and your decisions are part of the foundation of the criminal justice system here in New York State.
In a typical year, in courthouses like these all across the state of New York, grand juries such as yours will hear some 35,000 presentations or cases. Grand jury presentations range from the 9,000 or so each year in the more populated counties of New York City to less than 100 in smaller counties. To keep this vast justice system moving swiftly, fairly, and efficiently requires a dedicated corps of judges, court administrators, attorneys, and grand jurors just like you. I'm Jonathan Lippman, Chief Judge of the state of New York. More than a decade ago, the court system launched a comprehensive program of jury reforms. I'd like to share some of the improvements with you. For one thing, we made the jury selection pool much broader and more inclusive. Persons from all occupations, professions, and income levels are now expected to serve. This rich mix of all segments of our society is our best guarantee of a truly diverse and representative grand jury. Further, we've established convenient qualification procedures. Juror qualification questionnaires can now be completed online or by telephone. Today, jurors are summoned less often, and jurors who serve more than 10 days are excused from service for 8 years. In addition, every juror is now entitled to one automatic postponement, online or through an automated phone system, and may even select a date to serve. We've created a Grand Juror's Handbook, which includes Criminal Procedure Law Section 190 and is a handy guide you can refer to throughout your service. We've made a concerted effort to provide you with comfortable, clean, secure facilities and amenities. And with your help, we want to continue making improvements. If you see something that could be improved, please tell us. The fact is, we want to do everything in our power to make your grand jury experience as satisfying and rewarding as we possibly can. In return, we ask you to bring to your grand jury duties a true sense of involvement and dedication. Your mission is twofold, really. On the one hand, to use your power as grand jurors to indict those whom you believe have committed crimes against society. On the other, to use your power to protect people against unfounded accusations by the state. Without your commitment, our system simply doesn't work. But working together, we will continue to ensure for all of us our most basic American heritage, justice for all. Thank you for your time and your good service.
Basically, it was a great experience, and I was glad to have participated in it.
Well, I found working with 22 other people was rather interesting. It made for some good arguments. I discovered that people have other opinions, and I found I had to listen to that, and I learned from listening to other people.
It was a lesson in people skills, and it was a lesson in the law.
I learned a lot about my community. I learned a lot about the legal system, the judicial system. I guess my head was buried in the sand a little bit, and serving on the grand jury took my head out of the sand and made me aware of what was happening around me.
I felt that was good because, you know, just serving your country, and it's enjoyable.
I think the jury system is a great system, and I certainly wouldn't change that at all.
People should be aware that we really need this system. I think this is one of the things that makes this country special.
I think everyone felt the same as I did about this, that it was a great privilege to be able to do this.